We'll hear re-argument this morning in Case 08205, Citizens United versus the Federal Election Commission. Mr. Olson.
Mr. Chief Justice, and may it please the Court, robust debate about candidates for elective office is the most fundamental value protected by the First Amendment's guarantee of free speech. Yet that is precisely the dialogue that the government has prohibited if practiced by unions or corporations, any union or any corporation. The government claims it may do so based upon the Austin decision that corporate speech is by its nature corrosive and distorting because it might not reflect actual public support for the views expressed by the corporation. The government admits that that radical concept of requiring public support for the speech before you can speak would even authorize it to criminalize books and signs. This Court needs no reminding that the government, when it is acting to prohibit, particularly when it is acting to criminalize, speech that is at the very core of the First Amendment, has a heavy burden to prove that there is a compelling governmental interest that justifies that prohibition and that the regulation adopted, in this case a criminal statute, is the most narrowly tailored necessary to accomplish that compelling governmental interest.
Mr. Olson, are you taking the position that there is no difference in the First Amendment rights of an individual? A corporation, after all, is not endowed by its creator with inalienable rights. So is there any distinction that Congress could draw between corporations and natural human beings for purposes of campaign finance?
What the Court has said in the First Amendment context, New York Times versus Sullivan, Grosjean versus Associated Press, and over again, is that corporations are persons entitled to protection under the First Amendment. Now,
would that include today?